It's important to bring you together to remind the public of some of the key facts in the Julius Jones case that I believe are being manipulated to fit a narrative in a orchestrated effort to get Mr. Jones off of death row and perhaps out of prison entirely. And we've heard a lot recently from those who are advocating for his release. I'm here today as an advocate for the late Paul Howell and his family, and I'm here to advocate for the justice that our legal system owes them. They are the victims in this case, make no mistake about it, and the pain of their loss is revisited with each misguided public appeal on Mr. Jones' behalf. There are a lot of facts, and I won't cover all of them for you. Most of them should be in the packet that you've been provided, but let's deal with the first and most important fact. Julius Jones murdered Paul Howell in cold blood in front of his sister and daughters. No celebrity imploration or profusion of misinformation will change that. The information that we're releasing today is from the trial transcript, and it disproves every claim that he is innocent. I strongly encourage those calling for his commutation to read the compelling evidence in this document. Julius Jones had his day in court numerous times. I'll begin with reminding everyone the story around the infamous red bandana. His attorneys complained was never tested. It was tested in 2018. The conclusive results of the DNA profile show the probability of the DNA belonging to someone other than Jones is 1 in 110 million. Moreover, this bandana was tested for his accomplice, Chris Jordan's DNA. Chris Jordan's DNA was not found on that bandana. During the investigation, officers found the murder weapon wrapped in that red bandana and hidden in the attic space above the ceiling of the closet of Jones' room. And hidden behind the cover of the doorbell chime in his parents' home, officers discovered a loaded .25 caliber magazine belonging to the gun that they found. Both the bullet that killed Mr. Howell and a bullet recovered from Mr. Howell's Suburban were fired by the gun found in the attic. Something else that the public needs to take note of. Subsequent to Mr. Howell's murder, Jones pled guilty to robbery with a firearm and unlawful possession of a firearm. This offense arose out of the armed carjacking of a vehicle outside a Hideaway restaurant the week before Howell's murder. The stolen vehicle was recovered from a Norman apartment complex where Jones lived. After Jones and his friend were arrested for Howell's murder, the key to the stolen Mercedes was found in the cutlass shared by Jones and his accomplice. In other brushes with the law, Jones attempted to elude a police officer, was arrested while driving another stolen car in which he had a loaded gun. He robbed a jewelry store at gunpoint, committed another carjacking at the same hideaway during the same week, and fought with a detention officer. Alleged juror bias. The racial bias claim by a juror was thoroughly explored and investigated. Previously, during the trial, a juror reported that she heard a provocative comment, not a racial comment, but a provocative comment by a juror. The trial court thoroughly investigated this allegation, interviewed each of the other jurors, none of whom heard the remark. Moreover, the juror indicated that they had only heard part of the remark, and that juror was not even sure that there was a reference made to Julius Jones. And at that time, the reporting juror said nothing to the trial judge to indicate that the juror also used a racial epithet. The Oklahoma Court of Criminal Appeals determined that it is highly improbable that the reporting juror failed to make the current racial bias claim clear to the judge at the time it allegedly happened. Alibi. Jones affirmatively claims that he was at his parents' home at the time Mr. Howell was murdered. A hearing was held on this claim in state court, at which his attorney testified that he discussed the alibi with Jones more than once. And Jones said that he was not at home that evening, that his parents were mistaken. I'll quote from the transcript. Question: Mr. Jones, Julius Jones, denied to you that he was home the evening of the homicide. Answer: sworn testimony. Yes, ma'am. Another of Jones' attorneys, Malcolm Savage, also confirmed that Jones denied being at his parents' home the night of the murder. In addition to Jones' denials, Jones' family claimed another party was with them the night of the murder and could corroborate the alibi. That witness denied that she was at Jones' home on the night of the murder. Megan Tobey's description. Megan Tobey is Paul Howell's sister, who was in the vehicle at the time of the incident. It is widely described that Mr. Howell's sister, who was a witness to the murder, described the gunman as looking more like Jones' accomplice the night of the murder. Advocates for Jones say in her description that she saw braids or cornrows. But, according to the trial transcript, she said she did not see braids or cornrows. She said she could see about a half an inch to an inch of the man's hair between his stocking cap and his ear. These are just a handful of the misleading statements advocates for Julius Jones are perpetuating. As I said, we have more in the handout we've provided, and we can get the correct information for anyone who needs it going forward. Julius Jones is guilty. He murdered Paul Howell, and he needs to be held accountable. Mr. Howell's family will never have closure. His two daughters, now grown, had to grow up without their dad. The family was ripped apart by this senseless murder. In my meeting with the family last week, they all described Paul as the golden boy in the family. He was clearly his father's favorite, but none of his brothers or his sister ever took umbrage at that. They also advised that losing Paul also killed Paul's father. He was never the same. So, Julius Jones has been convicted, and no PR campaign can change these facts or refute this evidence. The last thing I will address is last week I sent a letter in response to an inquiry from the Pardon and Parole Board questioning whether or not death row inmates are eligible for commutation. My letter to the board referenced a 2012 Attorney General's opinion that established that the board has constitutional authority to recommend and that the governor has constitutional authority to grant commutations to death row inmates. This office will always follow the law, despite rhetoric to the contrary. Rhetoric last week by Mr. Jones' lawyer, who said this office would not follow the law, alleging we would be a biased actor and engage in a flimsy legal cover. Both of those are quotes. I know my responsibilities as Attorney General, and I am faithful to them. It was clear in the 2012 opinion, and it was clear in our review of that opinion, that the governor and the Pardon and Parole Board have this authority, and that Mr. Jones has a constitutional right to be reviewed for commutation. That's the law. I would ask that Julius Jones advocates, as I try to be, are responsible to the public with respect to their efforts on his behalf.
I still believe in Mr. Jones' innocence, and I'm speaking from probably a different aspect as many than other people, because I am a family member, I am a daughter of someone who was murdered, and also someone, those that were held accountable were also given the death penalty. And that death penalty was literally commuted to life without parole. And so while as some of my family did not have an issue with the death penalty, I myself don't feel like the death penalty is something as a sentence that should remain. I think it should be abolished. So I'm hoping that, the families, so I certainly understand what the family of Mr. Houck is going through. I've dealt with that, and I know every situation is different. I know the angst and the pain of such great loss in such a tragic manner. But I always wanted the correct people to be charged and their sentence to be appropriate. But I personally do not agree with the death penalty.
What is it to you that still stands out about this case you think they might have gotten wrong?
I don't know. I think now, really, it seems like we're beginning to argue semantics. And this is someone who's also having to deal with the emotional pull, because it's very triggering when you are also a family member of a victim, which means you're a victim yourself of a crime, especially that has taken your loved one. But some of the instances that I have paused with, if them not addressing certain issues. We heard about the judge or the person who's associated with the Pardon and Parole Board making inappropriate statements, seeming like that was intimidation. That was not addressed today. Understanding that there were some inconsistencies even at the trial that haven't really been highlighted. And so those are my personal concerns, and I think the concerns of the general public as well, those that are advocating for justice for Julius, as well as just wanting the judicial process to remain a system of justice, which a lot of times it seems like it's a system of injustice that we're presented with.
I know you weren't surprised, but did you hope that, given all the recent attention from celebrities, athletes, that they would lean in a little bit of a different direction?
Of course we did. And I am hoping that the family will still continue to push for justice on behalf of Mr. Jones. I know that I am committed to continuing to do that. I am very appreciative, as well as I know the family has expressed their appreciation for the nationwide and the international support that they've received. So I'm just saying that we're going to continue to pursue it.
Still stay on the list of demands from Black Lives Matter OKC?
It will certainly still stay on that list of demands.